Good morning.
Morning.
Morning, Your Honor.
Okay. Do we have I see something labeled court reporter backup. So do we have a court reporter? I only ask so I can make sure and call the case nice and pretty for them.
Yes, Your Honor. Brandon Roberts
Okay.
here.
Excellent. Mr. Roberts, I'm going to call the case formally so you know to go ahead and start taking down. This is going to be a hearing on plaintiff's motion for expedited discovery in the case of Lucas Zubinski versus John Midhour et al. Case number 25 CV 011667. To the extent I've just butchered anybody's names or the proper pronunciations of them, I apologize. Um, just by way of back, well, let me start with this. If I could get announcements for who all I have here this morning on behalf, starting with Mr. Zabinski.
Morning, Your Honor. Richard Robbins and my colleague Cody Newman on behalf of Mr. Zabinski, the plaintiff.
Thank you. And who do I have on behalf of the defendants?
Ryan Pumpian and Virginia Ice on behalf of all defendants.
Okay, thank you, sir. Um, thank you very much. So, just by way of background, um, I'm going to just put on the record a little bit about how we got here. And then if either of the parties wants to supplement or correct anything that I say to make sure it's accurate, that's totally fine. So this case started with, it was filed in late August by the plaintiff, and it was followed up in early September with an emergency motion for expedited discovery that was filed on September the 5th. And then the court granted that order ex parte on September the 8th. And then counsel for the defendants requested a hearing to revisit that issue. And the court, after having a fairly fulsome discussion with Mr. Robbins and Mr. Bloom, agreed to vacate the order, which the court did on the 15th of August, excuse me, September. And then also in that order entered a briefing schedule instructing the parties, hey, especially the defendants, you've not had a chance to respond other than the, oral argument that we had on during the hearing. So write a response. And at that time, Mr. Robbins requested an opportunity to provide any supplemental briefing. And that's sort of where we've left it. The um, the last thing I will say before I sort of hand it back over to the parties is that I have had a chance to read the supplemental briefing that I received from both the parties, and I have gone back as well, reviewed the complaint, which was verified, reviewed the original motion, and then reviewed the order that I originally entered that has now been vacated, just so I felt like I would have as clear an understanding as I could with as many facts as were available to me, at least that are part of my record. Anything before we get to the substance, anything anybody wants to correct or supplement regarding that, just to make sure that that record is clear for y'all's purposes. Mr. Robbins?
You accurately stated it, Your Honor.
Okay. Mr. Pumpian?
I agree.
Okay, thank you. So it is technically still the plaintiff's motion for expedited discovery, Mr. Robbins. And so if you would like to, address the court and make your argument on that point, I will ask that one thing I noted in going through my review that I think would be helpful to the court is, do you actually have the discovery? Because one of the things that I started thinking about when I was reading the additional briefing is, what is the actual discovery that is sought to be served, rather than the entities about which questions will be asked or the entities to whom the questions will be directed? It might be helpful to the court, depending on the nature of where this goes, like the actual specific discovery requests that you intend to um, serve if the court allows you to conduct expedited discovery. But with that question, go ahead, Mr. Rollins.
Thank you, Your Honor. We did serve discovery, the actual discovery requests. I'm not sure they were filed with the court. I can ask Mr. Newman. Typically, obviously, you don't file those with the
No, of
court.
course.
We, I mean, the nutshell was the same, which is we wanted the purchase agreement and the closing related documents, settlement statement. As Your Honor knows, there are a lot of documents that are prepared in anticipation of a closing. And if they hadn't closed, which Mr. Pumpian had represented, they had not yet closed. I was sure there were closing documents prepared and ready to go. And so I asked for that in the purchase agreement. Now, I will tell you that the the requests to produce were more detailed than that because, you know, for typical reasons, we didn't want to play the game of, haha, you didn't ask for this specifically. But that boils down to it. Your Honor saw my email to Mr. Pumpian after what I had thought was a constructive phone call, narrowing down what we were looking for, and even saying we wouldn't go to the third party if we got the documents from the defendants. So, I remain, should Your Honor re-enter the order, as obviously we think you should, we remain willing to work with them on the scope. But I tried to distill it down. It's pretty easy. We want to have the documents related to the sale and possible closing of the property. So if you would want us to send you what we serve, we're happy to. But to be frank with the court, I'm happy to narrow those down considerably if we can come to terms on those documents, which I think we would. So it's a long answer.
No, the only reason I'm sorry. The only reason I ask is because there were two reasons I thought it would be helpful to me. Number one is, to be clear, as I think I've made very clear during our last hearing, the order allowing expedited discovery, even if I were to enter one today as well, it doesn't limit the responding party's right to say this is wildly overly broad and I shouldn't have to respond to it or take any other remedy. The only reason I asked is that in looking at, the nature, if in fact this is, to the extent it's an extraordinary remedy outside the civil practice procedure, right, that ensuring that it is as narrowly tailored as it can be to accomplish the purpose that's trying to be accomplished. That's the reason I asked. So, but to the extent that it has been served, I think that was really the main question I wanted to have. And I think you've answered my question, Mr. Robbins. So if you'll go ahead with your
Sure.
argument regarding your request for expedited discovery.
Thank you, Your Honor. And I would be a few minutes because Lord knows you've already heard a lot on what is a pretty narrow discovery issue. But let me first start with Mr. Pumpian. Did I pronounce your name right, Ryan?
You
Is that
did,
correct?
thank you.
Okay. Sent us a rather disturbing email about an hour ago before the hearing, which causes us a tremendous amount of concern. And I think it might be helpful if Mr. Pumpian, rather than me say what he's told us this morning, if you hear it directly from him, because I think it relates to what I'm going to say.
Mr. Pumpian,
found-
care to share?
Sure. I found out last night after we had both filed our respective briefs that the property is no longer under contract. I don't know
As
the-
in it closed or as in the contract fell apart?
It fell apart.
Okay.
Right. We don't have a deal anymore at this point. So I don't know any more than that. I don't know the reasons. So that, real estate is risky. By calling it disturbing is a little strange because this is real estate and it's a risky business.
Well, I'm sure Mr. Robbins will tell me why he finds it disturbing, but I think the important part is understanding, for me at least, before I hear from Mr. Robbins about why he's concerned about that, is that your representation on behalf of your clients is that the deal that was at least a part of the concern for Mr. Robbins' client, that it would happen without his having any visibility into it, and that the proceeds of it could be hidden away in some way that was detrimental to his client. You're representing that that deal has fallen apart and there is no longer a contract for the sale of the disputed property. Is that correct?
That's correct.
Okay. Mr. Robbins?
Well, one can imagine our concern, which is as of 5 o'clock yesterday, and after 2 weeks of battling, we were told that there was an executed purchase agreement, and there was going to be a closing. And then an hour before this hearing, we're told that the contract is off. I am not suggesting anything about Mr. Pumpian. I'll take him at his word. That's what he was told by his clients. But I do not have the same lofty opinion of his clients. Yes, deals get called off. They also get amended and reinstated. And here, to have a deal of this nature somehow called off shortly before this hearing where we're seeking documents about the deal with no more information even heightens our concern whether it's true, for one thing, whether we're going to find out that the deal has been reinstated at 11 a.m. this morning, which closed this afternoon. Whether it's being restructured to do exactly what we are concerned they would do, which is do it in a manner which makes it impossible for our client to get his interest. If anything, it heightens our concerns. I think it takes away their arguments that there are somehow sensitive documents that shouldn't be shared with us, even under a protective order, when they're now saying the deal has been called off. So we wanted to get that on the record because I don't know. We found out about an hour. I have 20 or 30 questions I could ask Mr. Pumpian to send us, see what the deal is. But we just do not, for the reasons that we outlined in the verified complaint, and more particularly the dozens of emails and text messages that we got from defendants or between defendants about their activities. We just don't know what they're up to, and it doesn't change our position on getting these documents, which will be produced. I mean, there's no issue. These are discoverable documents and that they're pertinent. I mean, there's no issue at all. All we're talking about is timing. Let me, and I won't argue what we've argued yesterday and earlier, but let me highlight one thing because it relates back to a point your Honor made about expedited discovery. And what struck me in defendant's response was the statement on page 3, the week of September 1st, 2025, counsel for the parties exchanged emails about scheduling a call to discuss the potential for an amicable resolution. I don't want to get into the back and forth, but after we didn't have a call until after we filed the motion. I'm not going to play, go into the hour by hour breathless retake of the communications. But the point is, we didn't have the call until after we filed this motion, and Mr. Pumpian and I talked. I think it was about an hour. He said his views on the case. I said my views on the case. We talked about resolution, which I'm not going to go into the details, but we did have a talk about resolution. And as is obviously the case, I needed to see certain documents. We can't even be in a position to be sure about what our potential damages are or whether we even reinstate our client's 1/3 interest until we saw what the deal documents were. If they were going to be selling the property And just getting cash, that's one thing. If they were going to be, I mean, I don't have to tell the court, there's lots of ways you can structure a real estate deal. That's why I wanted the documents. I thought we had good discussions about what we needed. And as you saw, I limited, just like you would expect us to. You want lawyers to work these things out, and we tried. And then the next day we had the hearing, and it was completely going backwards to nothing, and we haven't talked since, even though I've had a request outstanding. I've invited further discussions. I don't think Mr. Pumpian will disagree with that. So when we all agree that expedited discovery is a matter of the court's discretion, and it's not only important for our claims, which, by the way, are not strictly money damages. We mentioned, I find constructive trust to be very important in a situation like this, where, you know, our position is it's not their money. We're just seeking damages. It's our money. I mean, it's plaintiff's money. That's what he is entitled to as a partner. But it's also important to exchange information. I mean, heck, we exchange information without discovery requests. I frequently recommend doing that to get to the bottom of a case sooner than later, and see if you can resolve it, or at least come to some sort of structure going forward. Because, you know, the way this is going with 2 hearings now on a narrow discovery motion, you know, we're looking at 2 years of hearings, discovery disputes, et cetera, et cetera, et cetera. I mean, this case isn't going anywhere at this rate. And if we could share some documents sooner than later, information sooner than later, perhaps we could get it resolved sooner than later. I don't know, but they said this in their brief, that that's something that they were interested in. I'm interested in, but I can't do it in a vacuum. And they know that. Mr. Pumpian knows that. He wouldn't negotiate in a vacuum either. So I wanted to mention that. You know, we could go back and forth on the case law and so forth. But I just want to say we don't have, and the law doesn't require us necessarily to show irreparable harm and basically prove up the merits of our claims, as well as prove up a motion for injunctive relief before we file it, just to get limited documents. I mean, that's an impossible standard. Expedited discovery is not like a mandamus or habeas corpus or anything. It's not so extreme a measure that it requires all of this proof, basically proving the case before you can even get documents a few months early. I mean, that's what we're talking about here. You know, we don't file suits lightly. We don't, Your Honor could see by the length of our suit, and we provide backup records. So you don't have to, Mr. Bloom described it as wild-eyed allegations. Well, you can just look at what we attached to the suit to see there's nothing wild-eyed. I think he meant something other than wild-eyed, but using that expression, you can see we're just not making a bunch of allegations. And in fact, some of the best evidence against Mr. Midhour is what Mr. Cohen, the co-defendant, said about him, about trying to bamboozle and going our client and going back on his agreement with us, you know, which that's some of our best evidence. But so, you know, you could see from the letter agreement, which mentions agreement 10 different times, and you can see, like I said, the language in the letter agreement, which it was like somebody looked at what are the elements of a promissory estoppel basis for an agreement and put that language in the letter. So there was no doubt that we were going to be, or I say we, my client was going to be acting in reliance on this. And he did act in reliance on that. And look where it's got him. So, I mean, this is going to go ultimately all the way unless we are in settlement position sooner than later. I will say our concern is very heightened by, what I will say, last minute maneuvering by the defendants on closing in on a contract. And I don't, I'm going to add to my list any documents related to this so-called cancellation of the contract. Because it can't, saying a deal is off could mean one of 100 things. But I don't know what's going on. I don't know if this is going to be an offshore deal. I don't know where the money is going, if it's going to be reinstated. I don't know what's going on at all. And we need documents related to that so we can come to the court and say, Your Honor, here's the situation. You can see our concerns now. But I also mentioned those documents are essential if we are to have meaningful settlement discussions. And I thought Mr. Pumpian and I were on the same page about that, quite frankly. So I refer to our briefs and everything, but this is, a discovery issue. And I'm trying not to overdo it here because I'm not asking for depositions. I'm not asking for wide-ranging discovery, just some basic issues that are important not only to our claims, but to try to resolve the case.
Understood. Thank you, Mr. Robbins. Mr. Pumpian, before you start, I see on my screen I've got some people here. I think for a hearing that was moved, I just wanted to give you freedom to leave. Mr. Tazi and Ms. Taylor, if y'all could tell me what you're here for. Well, they may not be here, so never mind.
Yes, Judge. I'm here. I wasn't sure if the hearing had been moved, so that's the only reason I'm here.
So, Mr. Tazi, I'm going to let you, if you need more specifics, you can talk with my staff attorney, but you're in the Atlantic Stacks versus Ballou case, right? Or
That's
the other way
correct,
around,
Your Honor.
Ballou versus Stacks.
That's correct, Your Honor.
One, I believe that we had a settlement announcement yesterday, but I could be mistaken about that. And two, I thought you were on leave and that we had acknowledged your leave, sir. So
I am on leave. I didn't receive the acknowledgement, but that's fine. I'm just here just in case the court had questions for me.
well, I very
Actually,
much appreciate your appearance, but you are driving and also probably on fall
Yes.
break with your kids. So get off my Zoom and go have a good day, and we will reschedule as necessary.
Thank you, Judge. Okay. Bye-bye.
Thank you, sir. Sorry for that interruption, Mr. Pumpian. Go ahead, please, Mr. Pumpian, with your response.
Thank you. So, and to clarify, the issue about the no longer being under contract, that came up yesterday. That was not something that we've been sitting on and sandbagging on. That came up yesterday. As I said, I would have said something in my brief had I known. I didn't understand that till last night. And my understanding, it's a business issue. This is not something that defendants made a decision on based on this litigation to somehow undermine this hearing, or that would be the tail wagging the dog. We all had an interest in this sale proceeding, probably plaintiff the most, but he hasn't invested any money and my folks have. So, perhaps this is worse for my clients. They have millions of dollars at risk and plaintiff has nothing at risk. So to suggest that my clients did this to somehow influence the hearing makes no sense. And that's just not what happened. Now, as I said, real estate is risky business. It is very speculative. I don't know if the deal gets back on tomorrow or a new buyer comes in tomorrow. That's just the nature of the business. I don't know what will happen. I don't know that anyone can predict. I'm just reporting what I know as fact today. But I do think it illustrates some things about the case. One, it illustrates the prematurity of the suit as a whole. He's seeking damages, and what he wants is to impound the proceeds of a sale that now is not going to happen, or now is not on, and may or may not happen in the future. So I always thought the suit seemed premature. They want to impound sales or proceeds of a sale that has not happened, and that has played out. And it demonstrates there is no emergency. Not only is there no sale pending right now, there's nothing happening at all. There's nothing to impound. So I think that means there's even less need for expedited procedures, and we can just proceed. I'm not suggesting the case is moot. It may not be, but we can just proceed in the normal course, I believe. And that standard is good cause. They have to have good cause. I agree with Mr. Robbins. And the court. The statutes, the discovery statutes, do not require any particular establishment or proof of irreparable harm in order to expedite discovery. They just don't give the court discretion. So the standard is just the normal good cause under any discovery issue to expedite. But the reason plaintiffs gave for their good cause was because they were going to suffer irreparable harm. And that's just not true. What they seek is monetary damages. I know they talk about, they use a lot of injunctive language, constructive trust, or a seizure order, or something like that to the proceeds. But what they are really seeking are the proceeds. They're not seeking to stop the sale or do anything that is non-monetary. They are merely trying to capture money. And money, typically, the general rule is, if money damages are there, you don't get injunctive relief. Now, there are exceptions. And I think the exception that they cite, the SRB or SPB case,
It's constructive trust.
it is a constructive trust. And the facts of that case are exceptional. And it's different. I think the key difference in that case, first of all, they had a bunch of discovery, at least 6 months worth of discovery. But the key difference, I think, in that case is that the bank lent money to the borrower. The bank was out the money. It spent the money, and the agreement was to have collateral, $35 million in collateral, to protect that loan. And what the defendants did in that case is apparently dissipated that collateral. So the banks had a really good reason to go track down the collateral that by contract they were entitled to have. And they were out that money. Obviously, they had lent that money. That is nowhere near the facts of this case. Even just looking at the verified complaint, they don't allege they spent a dime on this. They're not out any money. So it's just not analogous at all. And I think the facts of that case are so exceptional that it demonstrates, sure, when you have extreme facts like that, it makes sense to have an order freezing money. In this case, there's no money to freeze as we sit here today. And
Well, to be clear, although I understand certainly from our prior hearing, Mr. Bloom's argument, some of the briefing that I've seen clearly characterizes that one of their concerns is that this is really about money. But back to that sort of argument that was made in the briefing about putting the cart before the horse, right? Mr. Robbins hasn't actually asked me to attach anything. And yes, the purpose of this discovery might be, as you predict, right, expressly for the purpose of identifying a potential source of funds and then trying to persuade the court to in some way create a constructive trust or otherwise impound those funds. But they haven't asked me to do that yet. Right now, they're just saying we need documents and we need them on an expedited basis because of the nature of things that are happening. So anyway, that's just my general observation.
yes, I understand that. But again, they have, I'm not predicting what they might do. They have told us, all of us in their briefing, this is what they intend to do. They've said, we're going to file a motion for a preliminary injunction to get the court to hold these proceeds in some way. And so I'm going off what they're telling us they're going to do. I'm not trying to read the tea leaves on that. And so when they say that's their good cause, that's why I'm attacking it, that irreparable harm issue. And the other issue is that they're going to have to show a substantial likelihood that they will prevail on the merits. And I don't think they can do that. The LOI, the letter of intent, that they call the letter agreement, is just simply does not have all the essential terms. Yes, it uses the word agreement. Every document that is the subject of an agreement to agree case uses the word agreement. I mean, that's just the nature of those cases. but as we pointed out in the brief, there are a lot of missing key terms in the letter agreement. So I don't think that's enforceable. And that's what plaintiff is trying to get around. In other words, they have this massive presumption that they're going to win. So why don't we just skip to the end and give them the relief? They say that in their brief. We're gonna, obviously we're gonna win. So let's just, corral the money, and then get this over with. Mr. Robbins has expressed concern that this case may last for years. That's the nature of litigation. It may, and we have a right to file a motion to dismiss, and we are assessing those grounds
Sure.
right now. But they've already said, we haven't filed a motion yet, but they've already said our motion would be frivolous. So I'd like a chance to do that. I mean, this case, I think, was filed August 25th.
Right, but the reason that Mr. Robbins points to that he anticipates a motion to dismiss would be filed is his characterization that it is about delay, because of course a filing of a motion to dismiss occasions with it an automatic stay of discovery. And I absolutely agree that the defendants are entitled to file a motion to dismiss, and to have the merits of that motion adjudicated. But I think where we disagree about the purpose of that stay is not to prohibit any visibility into the case or to have any information from the other side. It's to minimize the investment that parties are having to make while a motion to dismiss is pending. I mean, that's the purpose of it. And I don't know that the fact that I understand Mr. Robbins' point. To me, it's no different than you saying he'll never be able to attach these funds because he won't be able to satisfy the standards and it's not appropriate. It's the same as him saying, well, any motion to dismiss they file would be frivolous and intended for no purpose other than delay. I don't know that I agree with either one of you, but I also don't think that position is dispositive to the outcome of a request for initial discovery at the outset on some limited issues, which is what Mr. Robbins characterizes his request as.
Yes, he does, but I don't see a need to expedite that as opposed to have a normal procedure. I mean, I don't know if we're going to file a motion to dismiss. I think there are certainly meritorious issues. As we've pointed out in our brief, I think they have a lot of challenges on the merits, but I think we're entitled, and every litigant is entitled, the opportunity to assess the case and make those arguments. Yes, the Civil Practice Act does stay discovery for 90 days when a motion to dismiss is filed, but those are the rules. They apply to every, and of course we can modify them. But to have us turn around, 10 days is a pretty extreme turnaround.
Well, it was 10 business days, right?
Yeah,
Which is
right.
still a ridiculously fast stretch. I get that. But 10 days is different than 10 business days.
Yes. So, okay. So 14 days. But again, if we were 6 months into the case and something had come up and, we've litigated this case and exchanged some documents, but something came up on an emergent basis, that's different than the beginning of the case when we haven't even filed an answer or a motion or address some of these issues. And now that we have this change on the business side too, I don't think there's any emergent issue. The other thing is, Mr. Robbins said something about there's no longer any confidentiality because they're not under contract anymore. That's not true at all. In fact, I think there's even a greater need for confidentiality now because the plaintiff was an employee of Cone Commercial, and he was terminated. And so now he's a competitor. I'm not sure if he started his own business or joined a competitor, but they're competitors now. And I understand we can work under a protective order, but we're probably going to have a two-tier protective order now to deal with that. So I think the confidentiality issues are even greater now than they were prior to. Also, addressing Mr. Robbins' comments about our settlement discussions, and I'm not going to get into substance either, but the point that I want to make is this case and all cases can proceed on two tracks simultaneously. We can be talking settlement and dealing with the merits of the case at the same time. And I hope we can still do that. I agree. I think our initial discussions were productive, and they asked for some documents that they would want to see in order to get more serious on settlement discussions. I understand that. I never agreed to produce those things. What I agreed to do was take those requests back to my client and have a discussion about it. And we're still in that process. So that may or may not proceed, and whether it does or does not has no impact necessarily on the merits, and the merits can proceed separately. I think there has just the complaint and the motion briefing from plaintiff's side just shows a ton of speculation. I understand their point, and it is a fair point that they don't have visibility into this transaction. I get it. But everything beyond that, all the accusations and implications that we're going to disappear money, and all the comments about the reputation and all of that is speculative and just improper and designed to kind of, I think, influence the court to bias them against us from the start. And so we feel like we're kind of trying to dig out of a hole in responding to those kinds of allegations and on an expedited basis. And I think that was the point or a point of the expedited basis, is to sort of keep us unbalanced and not allow us to actually get our footing and respond to the complaint and deal with things in the normal course. So that's all we're asking. Let's just proceed in the normal course. We may have a dispute over scope of discovery, like Your Honor talked about. I don't know. But if we do, we'll confer about it as we're required to do, and do the best we can and not take up your time further.
Thank you,
That's
Mr.
all.
Pumpian. Mr. Robbins, it's your motion, so you get the last word, sir.
Very quickly, likelihood of prevailing on the merits is not the standard for expedited discovery, as Mr. Pumpkin suggested. And I did not call there any motion to dismiss would be frivolous. I said meritless. And I said that for a reason. I don't use the word frivolous lightly, but I don't think it would have merit. On the constructive trust theory, I will just say, to me, there was partners. I realize it's an LLC, so technically members, but if one of my, if I got word that one of my partners had agreed on a fee with the client and was not sharing that with the law firm, and wasn't clear what was going to happen to that fee, yes, it's more than just seeking damages. It's like, we're partners and you're taking my money, but you don't have to decide that now. I mean, that's not something, but that's in our complaint. It's certainly something we're interested in. We've set out a pattern of dishonest conduct, which leads us to, quite frankly, doubt whatever the defendants tell us, including the announcement now an hour and a half ago, hour and 41 minutes ago, that the deal is off. I have no idea what that means, and I've been doing this a long time. Off doesn't mean off in real estate world. It can mean off until an hour later they agree on a different term. So I respectfully ask that the court grant the motion, but let me offer a suggestion, which is, if Your Honor grants the motion and Mr. Pumpian and I can see if we can agree on the scope of the expedited discovery, and so we can present Your Honor a proposed order with a limited scope. I'm happy to have those discussions. Mr. Pumpian would not be agreeing. I would not suggest that he should be agreeing to, the grant of the motion, but it's more of a agreement as to form of the order. And if he has confidentiality concerns, we send him a protective order. It sounds to me like he wants an attorney's eyes only right to designate. That's okay with me if it's not overused. Because frankly, at this stage, I don't really need my client would be very interested in what he believes his share is. But, if they want to mark something as attorney's eyes only, and then give me, if we have settlement discussions, give me permission to disclose certain things, that's okay too. I'm just trying to move this along. This is a serious situation, and it's going to go on. Both sides have resources, carry this case on for a long time. And the older I get, the less interested I am in doing that if business disputes can be resolved early. So, and I believe that passionately. So it's not just for settlement purposes, it's for related to the case, but it's also, why are we spending all this time on documents that they could literally send us in an hour, And the only update I would make to what I had previously asked Mr. Pumpian are documents dealing with the claimed cancellation or whatever it is, termination of the agreement. What is the status of that? I'm sure Mr. Pumpian doesn't want to play games with the court either, in terms of, telling you this afternoon, oh, well, the deal was back on and it closed for a week from now. I mean, he doesn't want to lose his credibility, and I don't want to lose my credibility if the deal is something other than what I'm imagining, and it's more than speculation. I've done a few hundred of these things. So anyway, that's what I'm requesting, and if we don't agree on a proposed order, we could submit something, different ones to Your Honor, and I'm sure Your Honor could quickly decide what to do. So it can be properly limited, and then we don't have to be back in front of you on their objections to our request to produce. Let's not waste time. Let's do it up front.
Thank you, Mr. Robbins. So here's, having listened to the lawyers, having sort of tried to put in context what I understand about the ongoing issues among the parties and what the likely legal claims look like, what they are now, whether there's going to be a closing or not. Here's where I think I come down. I think that part of the reason that the legal process exists, right, to file suit, is to enable a party to obtain information that they otherwise would have no ability to obtain, right? To compel or to request, and compel if necessary, information from other parties. That again, it sounds as if that information has been requested, not that there is any legal obligation to produce it until now, but that it has not been provided in the sort of normal course of discussing an ongoing business dispute that has risen to the level of litigation at this time. And so, as I mentioned, as I have mentioned previously to the parties, I think that oftentimes, not always, but oftentimes, early discovery can be an important tool in helping the parties figure out what the issues really are, and what is how to narrow the case and how to figure out, what's going on and what might be the way forward. Now, because it is outside of the normal course, I do think that any type of discovery should be narrowed and that the scope of it should be reasonable. But in fairness, crediting Mr. Robbins' representation, and I have reason independently to credit that in the sense of personal experience, that many of the documents that he has said he is asking for are documents that would be readily available to your clients, Mr. Pumpian, in terms of it. Now, the scope of those documents and the materiality, et cetera, of those documents might be a different issue. But in terms of a burden on the defendants to produce them on short notice, it seems like that burden is relatively low. And so all of that is a long way of saying this. I do believe that the plaintiffs have shown good cause for some level of expedited discovery. And so I'm going to enter an order that allows for expedited discovery. I think there are two things that are critically important here. Well, three. Number one, I'm going to restate what I've said before today's hearing. I said it in last hearing. My ruling allowing expedited discovery does not in any way, nor is it intended to, limit the ability of the responding party to provide good faith objections to the nature and scope of that discovery. Now, obviously, I don't want to see those be abused, but it's not my intention, especially on an expedited basis, to say, oh, but you can't assert any objections. That would be wildly outside of what is, I think, acceptable within the Civil Practice Act. That's number one. Number two, it is, I think, important because of the expedited nature of the relief that the court is providing to figure out timing of the reasonableness of when those discovery responses will be required. And number three is to determine, and that's why I asked Mr. Robinson at the outset of the hearing, acknowledging that upon reviewing this and preparing for today's hearing, I realized I'd never actually seen the discovery responses, and I don't have to see them to actually approve them ahead of time. But I do want to make sure, to your point, Mr. Robbins, towards the end of your comments, that the requests are narrowly tailored to accomplish the expedited purpose that the court thinks good cause has been shown for, which is the ability of your client to assess and understand what actions are being taken that might help him understand his rights and also might give rise to his understanding of what his remedies might be. And so scope and the ability of the party to object, right, and to follow that process. And then that leaves me really with the issue of timing. So I did see that the parties, I think some email communication advised me that the parties, Mr. Pumpian, that you ultimately acknowledged service on behalf of the remaining two clients who had not been served. Was it Mr. Cohn and his realty company, I think?
Correct.
Yes.
And that y'all had agreed that everybody's answer would be due on October the 13th. Is that right?
Yes.
Okay. So within that timing, understanding that absent some stipulation to extend, that would be the date that if a motion to dismiss is forthcoming, that one would be filed. What timing are we looking at as we sit here now on September the 19th, that the original order was 14 days, which would be, I think, the 3rd of October, if I'm doing my math correctly. What are, other than obviously, Mr. Pumpian, your continued objections to the relief that the court is allowing, is there anything you would like to specifically address regarding the timing? Because again, Mr. Robbins has been fairly consistent in characterizing the nature of the requests he's making as things that are readily available and would not be particularly burdensome for the defendants to gather and produce, subject, of course, to even a two-tier protective order that the parties have discussed. What are your thoughts, Mr. Pumpian?
I think we'll have to review the scope. I did read the requests that they served initially, and I thought they were inconsistent with his representations that they were seeking narrowly tailored discovery. Now,
well, we lawyers are particularly bad at saying things are short or brief or limited or narrow. We're all bad at that. So,
right. Especially when it comes to drafts and all sorts of, and all communications about those sorts of things, are really hard to put a fence around and understand what the limits are. So I think we'll have to discuss those. So I don't think what they served is narrowly tailored, but that doesn't necessarily mean we can't get to an agreement on it.
okay.
The one
What
issue
about timing, sir?
So timing, ideally, I think I would be more comfortable if we could serve everything on October 13. In other words, we just get our documents together, whatever those may be, and our answer or other response. Again, I don't know if we file a motion. I understand it wouldn't stay discovery regardless.
Well, if you file a motion to dismiss, it would stay future discovery for that
Right.
90-day period. It wouldn't, to be clear, relieve the defendants of responding to this initial discovery that I'm authorizing on that expedited basis.
Right. That's my point. Right. So that date just makes sense to me since we kind of already agreed to that date, at least on the response. The other concern I had is third-party discovery. You know, they served document requests on us, and they served them on I think the third-party buyer. I don't know if they served it on they sent something to the broker on the deal, on the initial deal. I don't know if that was discovery or not. So I don't know how the court feels about that. I mean, it's very possible the fact that they served discovery on the would-be buyer is what gave them cold feet. I don't know. I mean, I thought that was a bad strategic decision, but I don't know the cause. But that's certainly possible. But I guess that's what I would ask, is that we limit this discovery to us, to the defendants right now, and not involve these other third parties, because that potentially impacts business issues.
I believe Mr. Robbins has offered to limit the non-party requests, though I think the applicable rule and the considerations for service of discovery on non-parties is different than the one that we're discussing now relative to parties. But Mr. Robbins, also, it sounds as if that's something you're willing to discuss in terms of an ongoing basis with Mr. Pumpian.
What I would do is, and by I mean Mr. Newman, is
The
to
royal
send
we.
what we will do is send out much more narrowed requests just to the defendants today, which we can do. We'll cut way down and just send it to the defendants. I really think they can produce the documents next week. I mean, by the end of next week, if there's some category that they feel they can't, okay. I mean, Mr. Pumpkin has my cell phone number too now. I gave him. I'm readily available, much to my distress. But we can serve highly narrow discovery requests today. If he has problems, he can call us early next week. But 90%, if not 100% of these can be produced by the end of next week without any problem. I mean, it's been 2 weeks since we filed our motion for expedited discovery. So they've had a lot of time to deal with this. And we will, we send them a protective order, revise it, send it back to us today if you want. And we can get that entered. So there's no issue of confidentiality, just to slow things down.
Okay, so Mr. Newman, since I'm guessing you're probably going to be the one preparing this, can you please send me a proposed order? One was sent to me previously, so really it just needs to be edited a little bit, specifically to provide that I am granting the motion for expedited discovery, that the motion will require responses by Mr. Pumpian's clients, the defendants, on or before, I'm going to give you the weekend, Mr. Pumpian. So I'm going to say on or before October the 6th, which is slightly more than that. It's the weekend extra of the 14 days to October the 3rd. Also, I find that giving a hard date instead of number of days limits the extent to which we lawyers miscount or count days wrong or don't include the right days or not. And by we, I mean me. So that's what I'm going to do. That will still allow Mr. Robbins' clients a week to entertain what those documents look like and what they mean prior to receiving an answer or motion to dismiss, et cetera. Mr. Newman, if you will also please provide in that proposed order that the discovery responses that are being that the responses will be forthcoming to the new discovery requests that will be more narrowly tailored, that will be served by the plaintiff today.
Yes.
And that those responses will be subject to an agreed protective order.
Yes, Your Honor.
Um, I believe that's everything that I need included in that order. If you'll please make sure and send that to Mr. Freehoff in Word format. I will be able to change it to reflect anything I think needs to be included, and I'll be able to get it on file for you guys today. We can ask the clerk for expedited acceptance, but even if it's not, if we get it filed today, we will email it to you guys so that you'll know that it's on file. And then I may, if it's not already there, Mr. Newman, if you want to include, or I may add just again some language to reiterate that the order in no way limits the ability of the defendants to assert good faith objections and to follow the court's process for asserting such good faith objections to be resolved by, meet and confer and discovery conference with the court. So. Understanding that that's going to be my ruling, anything else that you want the court to address or that you want to bring to the court's attention, Mr. Pumpian?
No, Your Honor. Thank you.
Mr. Robbins?
No, Your Honor.
Mr. Newman?
No, Your Honor.
Okay, excellent. Thank you all very much. Have a good day, a good weekend, and I will look for that order and get it on file for you as quickly as I see it.
Your Honor.
Thank you, Your Honor.
Thank you. Good morning.
Good morning, Your Honor.
Let's see if I can remember how to say, is it Miss Millord?
That's correct, Your Honor.
Oh, excellent. I got it right. And Mr. Prothro, good morning.
Good morning,
Um,
Judge.
Who do I have here on behalf of the petitioner, 120 Piedmont?
I believe, Judge, that Joseph Siegelman, that is his last name. He's here, but he's actually physically in your courtroom.
Oh,
He sent,
huh.
yeah, exactly. He sent an email saying that he was in your courtroom, and I think there's a hearing going on. So I don't,
Yeah, I'm not in my courtroom because I was not going to be in my courtroom today, I loaned it to the non-complex division.
okay.
So I think Judge Petty is in my courtroom. And this hearing is not going to take place in my courtroom. Mr.
So,
Freehoff, have you been in communication with Mr. Siegelman at all?
I have not, Judge, but if he is indeed in our courtroom, I suppose I could check with minimal interruption to, is it Judge Petty who's in there? It's my understanding.
I think that's who you said is Adam Petty.
Yeah. Would you like me to go in and call for Mr. Siegelman and ask where he's at in terms of the
Well,
business?
let me ask Mr. Prothro, did you discuss what Mr. Siegelman's intention was in terms of going somewhere that he could attend the hearing remotely?
no, Judge, we just received an email from him from inside your courtroom. He was just letting, I think he was sending it to Mr. Freehoff to let the court know that he was present, that he was inside the courtroom, and he was saying that there was a hearing before us. So I think he is thinking that you are there. Maybe this other judge is having a hearing before you do. So I can give him a call if he can step out of the courtroom, or I can send him an email and just say, hey, the judge is on the bench and this is going to be virtual.
Yeah, I think we're going to do both, right? Which is, Mr. Prothro, if you'll reach out to Mr. Siegelman, I'm also going to have Mr. Freehoff go out and see if he can locate Mr. Siegelman and
Mhm.
let him know that this is a Zoom hearing as was indicated on the notice, and that he'll need to, what arrangements we can make to maybe give him a few minutes to get situated somewhere that he can attend remotely. Mr. Freehoff, did you hear all that?
Yeah, the sheriff just came in addressing that. So I told him I'd be out momentarily to talk to Mr. Siegelman. I want to stick around just in case you had extra instructions for me, but I'm heading out there now.
Nope, that's it. And so, Mr. Prothro, that saves you a phone call since we already know he's out there.
All right.
I'm just going to turn off my video and audio until Mr. Freehoff comes back to report or until Mr. Siegelman jumps on to the Zoom, and we'll figure out what we're doing in terms of when we'll be getting started. Okay.
Sounds good, Judge. Thank you.
Thank you both.
Good morning, everyone. Just letting you know, counsel for petitioner is
Hey,
on.
that looks
Sorry.
like my jury room.
It is indeed.
Excellent.
Mr. Freehoff just set us up in here. We had come in person, but happy to join online, and I'll introduce co-counsel who's with me as well, who are in the room with me.
Okay. Well, I'm very glad that we were able to accommodate you. I appreciate Mr. Freehoff for problem solving on the fly. That seems like a really good way to give you the space that you guys need to make that presentation so you can log on. Um, one question I have, and then I'm going to take just like a 5-minute break while everybody gets situated and ready to get started. Do we have a court reporter? I had one on the Zoom for a long time, and then they dropped off. I don't know what case they were here for, but.
Oh, goodness. No, I don't think we have a court reporter.
I don't believe we do, Judge. I know the city didn't order one.
Okay, just making sure y'all are aware of that. My notices advise everybody that for civil cases, you have to find your own court reporter. So just making sure of that issue. I'm going to take a quick break, and it's 10:39, say 10:45, and we'll go ahead and get started as soon as I come back. Okay?
Thanks, Judge.
Thank you.
Thank you. Okay. So I see now I have Mr. Siegelman and Mr. Barry, I believe on behalf of 120 Piedmont.
Yes, Your
And
Honor.
then I have Mr. Prothro and Ms. Millard on behalf of the city. Are there, before we get started, are there any preliminary matters anybody needs to bring to my attention? Anything like that, Mr. Siegelman?
Well, yes, Your Honor. I mean, I guess a couple preliminary or housekeeping matters, if you want to call them that. We filed a notice of filing city code sections, certified code sections that are pertinent for this matter that are not included in the record that was filed. So those are we could consider those as exhibits or as just certified code sections, but I wanted to be sure that you were aware those had been filed, and to the extent we needed to pre-admit those or anything, I wanted to raise that. And then the only other matter that I have noted is we also filed an exception to the record because this matter actually went before the City of Atlanta's License Review Board, I believe 3 times, and the only transcript included in the record that was filed by the city was the final hearing, and we wanted the transcripts from the prior 2 hearings to be included as well. So we would respectfully ask that that exception that we filed be granted. But those are the only 2 issues that I have noted here.
Okay, 2 things. One, because the city code is available to me as a research matter, I can simply locate them online now, which wasn't the case probably just 5 years ago, but certainly 10 years ago or more. I don't know that they even need to be admitted as formal exhibits. I obviously have had the opportunity to review the relevant portions that have been cited by the parties, 1042, if I'm citing them wrong, and I think 88 and 88.1 are in there as well. To the extent that you feel that procedurally they need to be admitted, I'm certain that the City of Atlanta wouldn't have any objection to the admission of its own city code. What are your thoughts on that, Mr. Prothro?
No objection, Judge.
Okay. And then as to the exception, Mr. Siegelman, to my knowledge, those transcripts have not been made part of the record. I've seen no additional filing, and I'm not aware of them having been provided to me. Do you have them, and it is only that they are not formally part of the record, or is it that you do not have them at all?
We do have them, and they should have been attached as exhibits to the exception. So they, I'll have to double check that to be certain.
No,
but
they very well might have,
okay.
and that's entirely my fault. But I'm looking at your I see the exception that was filed, and I had. Yeah, I think they are attached, sir. That is entirely my oversight. So I do have them available to me, and I had previously been aware of the fact. I mean, I'd reviewed the exception and was aware that they had not been provided when I reviewed the record originally. So, okay. So those matters are taken care of. Any objection by the city to the court being made aware of and having access to those 2 transcripts that were for other proceedings involving earlier proceedings involving the same property or the same license?
No objection, Judge. Mr. Siegelman's correct. Those were prior portions of the same hearing, just held on an earlier date, so they should be included as part of the record.
Okay, excellent. So with that, Mr. Siegelman, I'm going to call upon you. Procedurally, by way of background, I mean, this is a request to review a denial of a license that was denied by the LRB and then I guess technically by the mayor. There was a motion to dismiss that was filed that was denied. And so where we are now is finally opportunity to reach that substance. So Mr. Siegelman, other than the transcripts that I've just acknowledged have not had an opportunity to read, I had read the record, and I am aware that this involves, I'm going to tell you what I think I'm aware of, and then you can take it from there and correct anything I say that's not right or supplement what you think is necessary. I'm aware that this involves a license to sell beer and wine by packages at what I guess was the racetrack gas station on Piedmont Road, which is, just for the record and full disclosure, one that I drive by routinely on my way to and from the courthouse. So I'm familiar with its location. As a person who lives in the city of Atlanta, I'm also familiar with some of the concerns that were expressed by some of the people at the public statements regarding how it had been operated in the past. And I did have a chance to read, as I said, the file in terms of the concerns that were expressed, particularly by, it seemed like a concerted effort by Georgia State students and others in the community, given its proximity to the campus. And so that's sort of where I am. I believe I understand that your client's position is that the public opposition is not a legitimate basis for the city to refuse a license if you've already met otherwise all of the particular requirements for the license, which your position is you already had by having been noted by, I think, a review that is conducted previous to the hearing. I think I understand that to be the procedure, that there's a review of the application that's done by some entity, maybe the police department that's responsible for those. And then there is an LRB hearing where you are able to present whatever you want. They hear from the community and they consider that recommendation. And that your position is that the denial of the license was arbitrary and capricious because it was simply based on public opposition and not anything else. And that's sort of what I think I understand your position to be. I'm going to hand it over to you and let you take it from there now, Mr. Siegelman.
Well, thank you so much, Your Honor, and thank you for taking the time to become so well versed in the issues and your thorough review of the record. And there's nothing that you stated that I view to be incorrect. I can perhaps add a little bit of additional color to that. So as has already been stated, I'm here with my name is Joe Siegelman. I'm here with my co-counsel and colleague Jeremy Berry, who represent the petitioner in this matter, 120 Piedmont Avenue, LLC. And my original co-counsel, Brittany Cambry, is still out on maternity leave, which is why there's counsel on the record still if somebody else who happens to not be present for this hearing.
Very exciting for her.
Yes, we wish her well, and we understand everything is going well, thankfully. So the legal standard for a matter such as this is relatively straightforward, and it sounds like Your Honor may indeed already be familiar with that standard, and that comes from a case in re Cherie Baps Corp. That is the most recent case, at least as far as petitioner is aware, governing this exact issue. And the case citation for that is 346 Georgia Appellate 434, 2018. And in that case, the Court of Appeals reversed a superior court that had agreed that the license an alcohol license should be denied. And what the Court of Appeals said was, in effect, that there must be objective and ascertainable standards that are known both to the government jurisdiction as well as to the applicant, so that they can determine and be knowledgeable about whether or not they would get an alcohol license. And although discretion is not necessarily eliminated through that legal standard, when there are objective criteria laid out in the code sections, the pertinent code sections of the government jurisdiction, but any, as you stated, Your Honor, public opposition or general concerns, they must be tied to specific objective criteria that would not be met. And in this instance, as you stated, there is an independent body that does determine whether the objective criteria is met. Here, that's the City of Atlanta Police Department. And it would probably be beneficial, although this is already in the record, we did separate it out as an individual exhibit. So it's already part of the court's record, but it's worth raising, and it's actually included in the License Review Board hearing cover sheet, where it's a one-page summary. I have a hard copy that I could hand to you.
Well,
but-
no, I think that your team sent it over to Mr. Freehoff, and that Mr. Freehoff provided me with Exhibit A and Exhibit B, which I did have a chance to review this morning. And Exhibit A seems to be a report to the License Review Board, a report to the NPUM, and then Exhibit. Let's see if I've got the right email. And then Exhibit B seems to be the NPU recommendation as denial.
If I
If
can
those are the
interject-
documents you're referring to, great. If not, let me know.
If I can interject, Judge Krause, I believe those are the city's exhibits.
Okay. So, Mr. Siegelman, if you have the ability to email me that document or direct me, because I have immediate access to the record as we're speaking. So if you can tell me what page it's on, I'm happy to be able to review it. Or if you have it electronically and you want to share your screen, you can do that as well.
So these were previously submitted. They are a part of the record. I'm happy to direct you to the record, but we submitted 4 exhibits just specifically for the hearing, only one of which is not part of the record already. But our Exhibit A, you had it correct. So maybe there's some confusion as to whether they're city exhibits or our exhibits, but it is the Atlanta Police Department's cover sheet for the License Review Board hearing. That's Petitioner's Exhibit A as pre-submitted. I'm happy to share my screen, or I'm still happy to email it to you if you don't have that. It would have been submitted prior to the last hearing. We didn't resubmit it yesterday for this hearing.
Okay.
But I'm happy to get that back over to you. But so that everybody can see what we're talking about. You'll recognize this, I'm sure, from your review of the record.
Okay. Go ahead, sir.
Okay. All right, I've got it in hand, but I'm digitally replicating here. Let's
I apologize for the having to
well,
transition.
no, and we knew that this was at least going to be in part on Zoom, so it would need to be potentially shared on Zoom as well. Oh goodness, screens. It is not showing up. Let me try this one more time. There it is. Okay. Okay. As I was saying, the Atlanta Police Department does an independent review, and they present to the License Review Board, and this is the cover sheet of the information. Hopefully you can see my screen. It's a yellow page.
I can, and I also was able to locate where they were filed into the record and access them that way as well. But I have them on my screen, and that way we're all looking at the same thing.
All right, perfect. Basically, right here, it notes that there was an NPU denial for this particular application. It notes the individual applicant, and then it states applicant's criminal history revealed nothing to prevent the issuance of this license. The applicant meets the legal requirements. And then it notes the information that is, I guess, included with this cover in the file where this cover sheet I guess introduces everything. And I included as petitioners Exhibit B and Exhibit C respectively, the number 4 fire letter and number 6 building letter, which can be submitted up to 6 months after the application. That's per code. We can pull that if necessary, but I don't think there's any objection that the fire letter and building letter were timely provided. In fact, it doesn't appear that there was a new cover sheet for each new date that this matter went before the License Review Board. So as of the date that this matter actually was heard substantively, the final hearing that resulted in the vote for denial, the fire letter and building letter were actually already part of the application in the record at that time. So my point is, in presenting this, and I'll go ahead and I'm happy to show Your Honor, or would like to just introduce the number 4 fire letter, which again is Petitioner's Exhibit B, and number 6 building letter, Petitioner's Exhibit C, to demonstrate that all the criteria was supplied, all of the all of the legal requirements had been met. And that's not a representation from us. That's a representation from the Atlanta Police Department. And at that point, the Atlanta Police Department then essentially gives this to the License Review Board, said, we've conducted our review. We are presenting all the information showing that this applicant meets the objective legal requirements. And we, the Atlanta Police Department, see no reason for denying this applicant a license. Now License Review Board, basically, you have an opportunity to double check us, make sure that we didn't, that we got this correct, didn't mess anything up. And assuming if we didn't, then presumably the License Review Board would vote to grant the license. In this instance, over the course of 3 hearings, there was testimony, there was general public opposition, all of it respectfully related to the prior ownership, not the current or new ownership, about really generalized issues or concerns, primarily proximity to Georgia State University, which this is a location that has had an alcohol license under the prior owner for some 30 years, and Georgia State was actually built somewhat around this location. This location was pre-existing, but regardless, there were those 2 general concerns. We don't particularly love how close it is to Georgia State, in our view, there were issues under the prior ownership, and therefore, we would prefer this applicant to not get an alcohol license. Notably missing from the record, certainly that we have found or are aware of, is any specific criteria or allegation pertaining to this applicant, the new owner, that would undercut or call into question the objective criteria. In fact, I don't know that Mr. Prothro is ready to concede this point, but I don't believe that the objective criteria having been met is actually in dispute. I believe it is undisputed, and that it's a matter of this generalized public sentiment being against, from some folks in the area being against this application, that prompted the License Review Board to move for denial, which, as Your Honor already pointed out, was not actually ruled upon or affirmed by the mayor of the city of Atlanta, who does have the last word, because no action by the mayor took place within 60 days of the recommendation. And again, this is all according to the city code, which I'm happy to refer to if needed, but none of this is in dispute. The mayor's inaction resulted in the recommendation of the License Review Board becoming the final determination of the city of Atlanta, which was a denial, requiring us to appeal to Your Honor through a petition for review to demonstrate, or at least hopefully demonstrate, that as the Atlanta Police Department found, and as was essentially undisputed and unchallenged in any of the hearings, our client met the objective criteria, met all of the ascertainable requirements and criteria for license, and under what we contend, Your Honor, is fairly clear law, again, from that case, In re Cherie Babs Corp., that the opposition that was presented to this application is insufficient to deny the license.
Let me ask you a question, Mr. Siegelman, because
Sure.
part of what in terms of looking at the standard for arbitrary and capriciousness, right? So let's assume that you are correct and that the city's not going to challenge that the basic minimum legal requirements that were obligated to be satisfied in the application were satisfied by your client. I think the part that I don't understand is, if in your characterization, it to me runs the risk of making the LRB merely a rubber stamp and not actually providing a meaningful opportunity to review what's the application that's being made, number one. And number two, specifically that public comment. I mean, that's really one of the most fundamental things that the LRB process is providing, is an opportunity for members of the public to comment on it. So what about that concern that if I say, well, the APD found they met all the legal criteria, that their finding based on the public opposition was necessarily arbitrary and capricious because it's not an element of that legal criteria. Then what about that concern that makes the LRB just a rubber stamp?
Well, thank you, Your Honor, and I appreciate the question, and I certainly understand where you're coming from. And while not necessarily relevant to this matter, I actually served in the City of Atlanta Law Department for 2.5 years, and during that time, part of my responsibility actually was advising the License Review Board, and it was a challenge because you would regularly hear public sentiment, whether it was significant, where there were multiple people who showed up, or whether it was one or two neighbors. Is rare for an application to not have, especially for an alcohol license, to not have some form of public input that is against the application. It's also not uncommon for a neighborhood planning unit, the NPU, to recommend to the License Review Board a denial based on that public sentiment. And I certainly understand that the City of Atlanta is controlled by elected officials. Elected officials have constituents. Constituents have concerns, and most elected officials want to be reelected. And so there's a dance here that I understand and appreciate. But it is an opportunity for people to be heard. But the issue, the reason for the License Review Board, as I see it, is to give the public an opportunity to say, APD, you got something wrong. The code specifies that the distance requirements, for example, whether it's a school or a church, that they are designed to ensure that the general welfare is protected. And those are the objective standards. And that is why the law is, again, in our view, very clear. Because both the city and the applicant need those objective criteria to understand, okay, to protect the general welfare, and I'm not going to specify this, but that a strip club can't be within 200 feet of a school or whatever. But those standards are there. Whereas if such an institution, if that was the only criteria, is 300 feet, then somebody can't come back and say, well, I still think it's too close. Well, there are already objective criteria in place, and we are not capable of overriding, even if there is overwhelming public sentiment. The standards are what the standards are. So I think if there was a concern tied specifically to this applicant and tied to the objective criteria, where although the Atlanta Police Department found, just using those distance requirements or whatever, that they found that it was within 105 feet, but it was actually 99 or 98 feet. And here we can show you why. Then the License Review Board could take that into consideration and say, we believe that the criteria here weren't met, and therefore we're going to vote to deny. But even with some public concern, when those criteria are met, the law requires that the license be granted. And again, here you have an existing location. I don't think there's going to be any dispute that the location itself meets all those requirements. And as the Atlanta Police Department noted, the new owner had nothing in his record to suggest that he did not qualify as an agent for this location. Hopefully, I believe my co-counsel might have something to add, if that's okay.
Thank you, Your Honor. Not trying to double team this too much.
Go ahead, Mr. Barry.
Sorry,
He's
not
muted
trying
now.
to.
Yeah, that's fine.
Sorry, not trying to double team this.
I'm muted.
Right. So what you need to do actually is not only mute, but you need to make there not be sound. You need to mute your computer to make there not be sound coming out of it, so that they don't interfere. I've learned from experience in the
Sorry
courtroom.
about that. We are sitting next to each other, so sorry
Yes.
about that.
I recognize
Your
the
Honor, your
background.
question is entirely correct. And just by way of background, I served as the city attorney for the two prior mayors, and the law department reported to me, and I represented the License Review Board and many other city commissions and review boards. The LRB is not a rubber stamp at all, but they as they should, are intended to check the work of the police department in this instance. So they're not a rubber stamp. Obviously, these are objective criteria, but we're all human. People make mistakes all the time. So with the, as Mr. Siegelman said, if a distance requirement, if the police found, for example, that the requirement had been met, but maybe, again, the police made a mistake, or that a building letter had not been provided, or the advertisement had not been run, or public notice. So the LRB is not a rubber stamp, and in fact plays a very important function. But our colleague, Mr. Hilliard, who handled this matter at the LRB, raised multiple times, and it's in the transcript, that all of the objective criteria had been met, and there was no denial by the LRB or anyone who appeared before the LRB that anything other than those objective criteria, that's all they talked about were items other than the objective criteria. And Mr. Hilliard said it multiple times. I don't have the transcript in front of me, but happy to point your honor to those instances in which he raised this. So the LRB is, in fact, a very important part of this process. And in this instance, it played out, or it should have played out that way, where the LRB should have seen that the objective criteria were met. But instead, all of the outcry and the concern was a prior owner that the LRB should have never considered whatsoever. In fact, it's a new owner and a new license application. So any conduct that occurred previously, frankly, is irrelevant. And the prior citations were. Oh, and I'm sorry, and there were no citations.
Mr. Hilliard is here. He's not participating as counsel in this hearing, but that's who my co-counsel, Mr. Berry, is. He's off camera watching on YouTube, but he's in the room with us. And sorry to jump in. I just wanted to make sure that was clear, that what was going on. But first off, anything related to the prior owner is not relevant or material for this application. That's the first point. Well, but even if it was,
hang on.
I think the point
Let me ask for some clarification
Mr.
on
Berry,
that point. Mr. Siegelman, can you hear me?
Oh, I'm sorry. I still have my computer muted. I couldn't hear you through his. Okay.
Happens to the best of us. So
sorry.
That's okay. Let me ask you for clarification on that point, right? Because while I agree with you that in an objective sense, what a prior owner did or didn't do might not be relevant, but isn't the historic experience of that location, regardless of who's managing it, relevant? Isn't it a relevant consideration for the LRB?
I would say no, unless those concerns are somehow concrete, where there was, maybe there were citations or some sort of violations. Again, none of that is in the record, certainly not the new owner, and there's nothing in the record related to the prior owner. Where there might have been some incident or something at this location, but only again if those are tied to the objective criteria that demonstrate that some form of the objective criteria wouldn't be met or shouldn't be met because of some conduct of the prior owner. It all must tie back to that objective ascertainable criteria, and again that we didn't come up with. It's specifically enumerated in the city code for all to see, and is there. There's a sort of a preamble to this that says these are the requirements, and we're making these the requirements to ensure the general welfare of the public is protected.
Thank you. I appreciate that. Anything else to add on behalf of your client? I know I interrupted. We were jumping back between you and Mr. Berry, and y'all trying to answer my questions, or do we want to hear from the city and then let you guys have an opportunity to respond?
Thank you, Your Honor. We nothing further at this time, but we would like to reserve an opportunity to respond to the city's council. Thank you.
Of course. Thank you. Mr. Prothero, am I going to hear from you, sir?
Yes, ma'am.
Okay, please go ahead.
Judge, I think that this is a fairly straightforward case. This is an appeal. This case was filed under the Superior and State Court Appellate Practice Act. That act does allow the Superior Court to review the decisions of a lower judicatory. And I think we all agree that the standard of review for that should be the any evidence standard. In OCGA 5-3-5, it outlines what the court should do in reviewing a petition for review. And it says, except as provided in subsection B of this code section or otherwise provided by law, a reviewing court shall review only matters raised in the record of the proceeding in the lower judicatory, 2, accept the findings of fact and credibility of the lower adjudicatory unless they're clearly erroneous. 3, accept a decision regarding an issue within the sound discretion of the lower adjudicatory unless such a decision was an abuse of discretion. And 4, to determine whether the final judgment was sustained by sufficient evidence. And there's case law, Emory versus Leviticus 260, Georgia 894, which has held that the appropriate standard for the sufficient evidence or substantial evidence standard is any evidence. In this case, Your Honor, there is a wealth of evidence. If you review the transcript from the License Review Board, the License Review Board had 3 different meetings earlier before we went into actual hearing. We discussed the fact that there are multiple transcripts because there were multiple hearings on this matter. In particular,
So, Arthur, forgive me for interrupting you, but before you get into the facts, I would like to go back for a moment and make sure that I'm clearly understanding the city's position regarding the standard, right?
Yes,
because clearly I'm familiar with the standard under the Appellate Practice Act. It's also relatively new in the sense that obviously we all know in recent years the legislature made an effort to get rid of all these, various procedure and process driven ways to get reviews. And so that's fine. But your recitation of the standard that the court is to apply is somewhat different than what's being urged by the movements here and the case law associated with these types of decisions are typically in the context of mandamuses historically. And so they're not in the context of the Appellate Practice Act. And they are talking about, and at least several of the recent cases that I was directed to by the movement, talk about arbitrary and capriciousness and talk about whether or not the decision was based on specific objective criteria. And so my question to you is, how does that substantive standard fit into this new appellate practice standard? Is it just that we're going to sort of shoehorn it underneath that abuse of discretion?
If I understand you correct, if I understand your question, Judge, no, it wouldn't just be shoehorned under the abuse of discretion. I do believe, again, if I understand your question, I do believe that in looking at the old certiorari rules, compare them to the new, that the legislature did make a point of saying that in the new statute or in the new rules that the court was to determine whether the final judgment was sustained by sufficient evidence. And I think that language, sufficient evidence, does have some case law behind it.
It definitely means any evidence, no question. I agree with you there. It definitely means the any evidence standard.
And that is the reason why I focus on that, Judge, because as the court acknowledges, there's very little new case law given the newness of this change in the Appellate Practice Act. But I do think that the legislator said what it meant, what it said, and said what it meant when it put down sufficient evidence, because it could have used any other standard if it wanted to, but it didn't. It chose that. And again, that language does have some history, some case law behind it. I do think that in reviewing the facts of this case, at the Superior Court sitting as the appellate court for the LRB or for other governmental agencies, is not coming in to relitigate or re-adjudicate the issue, but merely coming in to look and see if there was any reason, any basis, any evidence to support the original or the initial finding of the lower court or the lower tribunal. So in this case, Your Honor, what my position or the city's position to the court is that what we should be looking at is in the transcripts, the records, evidence presented to the LRB on the dates in question, which I believe were September 24th of 2024 and November the 12th of 2024. During those hearings was sufficient evidence presented to the members of the LRB to support the decision that they ultimately reached. And in reaching that decision, was their decision arbitrary or capricious? And I think because of the amount of evidence that we'll see in this case, this court should rule that it was not arbitrary. The decision was neither arbitrary nor capricious.
Okay. Thank you very much, Mr. Purther. I think having that more fulsome discussion about the standard and how they work together is helpful to me. So thank you for that. Now, feel free to hop into the facts as you were going before I interrupted.
Well, big picture, Judge, in listening to the petitioner's recitation of the facts, it appears that they are focusing very heavily, clearly on the objective standard, the objective criteria that were checked off by the license and permits unit, which is a part of the Atlanta Police Department. And I believe that Mr. Siegelman presented a cover sheet that showed that the applicant had met certain objective criteria. I don't see on that sheet, however, that it says that they see no reason to deny the application. I think it just says all the legal requirements were met. I don't think that the police made any statement as to whether the final application should be denied and accepted or anything. It just said that they met the objective standards under the law. And there are several objective standards. I believe most of them have found, let's see, in Code Section 10-48. I would point out to the court, just by point of reference, the authority to issue liquor licenses is given by the state of Georgia in OCGA 3-3-2, and is for the most part codified in the city code in some of the requirements set forth in 10-46. And in 10-46, which now I'm having computer problems and trying to get to that. 10-46 states that no alcoholic beverages shall be manufactured, imported, brokered, sold to wholesalers or other importers or brokers, sold at wholesale or retail in the original package or by drink, nor shall any tasting room be operated except under a license granted by the mayor as provided in this division. And the following city code section, which is 10-48, discusses the application itself and certain criteria that need to be met in order for that application to be approved. Importantly, subsection A of city code section 10-48 states, all persons desiring to obtain a license required under this division shall make written application to the licenses and permits unit of the Atlanta Police Department for that privilege upon forms formed by the License Review Board. So the License Review Board creates the form, and then the license and permit unit fills the form out. It goes on to say, though, the application shall consist of two sections. Section 1 of the application will be used by the licenses and permits unit and the License Review Board and the relevant neighborhood planning unit, the NPU. Section 2 of the license application will be used only by the licenses and permits unit and the License Review Board for confidential investigation. Code section 10-48 goes on to require that the applicant, after they've completed the application, must schedule a meeting with the local neighborhood planning unit. And, oh, okay, I saw the share came up. I thought I lost you, Judge.
I'm still here. And also, just to make it a little bit easier for you, I do have, as I mentioned, and I have it pulled up, the Muni code at library.municode.
Okay.
And so I'm actually looking along with you at the relevant code sections as you're talking about them. So just to let you know, I have access to that.
Thank you, Judge. It's helpful to know, and I'll also slow down so I can make sure that I clearly enunciate all the code sections for you so that you can catch up with me. But I believe that what you see on the screen now is the actual NPU denial. And you'll notice that in the NPU denial, it states that, let's see, let me blow up my screen. Lots of comments. It's listed as a denial. The NPU denied the application, and under the comments section, it says lots of comments regarding the target audience, those purchasing alcohol versus the population surrounding the location, students under the age of 21. The NPU—
And to make sure, Mr. Prother, forgive me, just to make sure I understand what this document represents, I'm very familiar with the city's NPU structure. I've been to plenty of those meetings. And so this is a report of the NPUM meeting where they brought up this agenda item and people who attended the meeting were given an opportunity, and they're reporting that at that meeting there were lots of comments regarding the target audience and the population surrounding the location. And then they are reporting to the LRB that they have denied that they recommend denying the license. Is that what I'm understanding this document represents?
Yes, that is correct, Judge.
Thank you, Mr. Prothero. Go ahead.
And if we'll return to Exhibit A from the petitioner's exhibit, you'll even notice on that cover sheet, it says it's designated as an MPU denial. And so the MPU did recommend, denying the applicant's application based on the comments that were made at that hearing. Now, City Code Section 10-48F, in particular subsection F4, states, in making its recommendation, the MPU shall consider and provide comments regarding any information contained in Section 1 of the application and any additional information the applicant provides at the MPU hearing. So that part of subsection F4 indicates that the application will have information in addition to the objective criteria. And if that type of information is transmitted or held or provided at the MPU meeting, the MPU needs to designate that. And I believe that goes back to that comment section that we saw in the MPU denial letter. It goes on further to say, the MPU shall specifically note any information not found within the application, but provided at the meeting and relied upon by the MPU in making its recommendation. And again, I believe that that comment section satisfies that provision. The MPU then attended the first LRB hearing. The first LRB hearing, well, actually, to be chronologically correct, I believe the first LRB hearing was on September the 10th, and it was reset for some reason. However, in the transcript that has been provided by petitioner, if the court is inclined to review the transcript, you'll see that while the LRB notified everyone that we're not going to hear the 120 Piedmont application tonight, there were several students who came forward and let the LRB know, hey, we're here and we wanted to recommend a denial, but we wanted to talk about this case. The case was reset for 2 weeks. They come back on September the 24th, and this is the first hearing. And during this first hearing, there was a great deal of testimony given about the MPU requesting or recommending a denial because they were uncomfortable with the security plan that had been proposed or agreed to by the petitioner, by the applicant. I believe Dorothy Hurst, who was the representative for the MPU that night, went to great lengths to say that they had reached an agreement with the applicant regarding cars on the parking lot for more than 20 minutes. And the recommendation or the agreed upon recommendation was that those cars would be towed. But when she met with the owner in person, the recommendation was he wanted to change the recommendation to just simply booting vehicles. And she felt like that was evidence of the fact or evidence that even though an agreement would be made, it may not be honored. And so the NPU recommended a denial. There was a great amount of discussion by Attorney Hilliard at that time about his client. And ultimately, it was determined that the applicant had not had any communications with the students themselves. And so the hearing was reset in order to give the applicant an opportunity to meet with the students and to meet again with the NPU. The final hearing date was on November the 12th. And at that hearing, it was the evidence that was presented indicated that, number one, the students and the NPU had requested certain changes from the applicant that the applicant was unwilling to make. Namely, they were requesting 2 full-time police officers at the scene. The applicant indicated that that would come at great cost and he wouldn't be able to satisfy that. And so they went back and forth on trying to come up with a compromise. Another suggestion was made that a request that the location only operate, well, let me change that the location shut down at midnight and reopen at 6 a.m. So rather than being a 24-hour, 7-day-a-week operation, that it would close at midnight and reopen at 6 a.m. The reason that was requested is that during those times, usually people who did not live in the area, namely students, who came there to buy alcohol would come and frequent the previous location, and that was generally the time that GSU police and the MPU believed that most crimes occurred. Again, the applicant denied that request. And then the third request was that the applicant not sell vapes and certain types of e-cigarette products because, again, those require you to be over the age of 21. And 90% of the students that live in the dorm across from the subject location would not be able to purchase those products anyway. However, those types of products do attract certain types of customers. And again, the applicant denied that request. So there were specific requests that were made by the MPU and made by the students that were not honored or not granted by the business owner, which is his right to do. But because of that disconnect, the MPU and the students felt that this was not an arrangement that was going to attract the right type of customers, and that it could potentially lead to an increase in crime, similar to when the previous owner owned the property. Several of the board members asked the owner very detailed questions about the economics of his business. They asked him questions about his security plan. They asked him questions about why he couldn't make these concessions. And ultimately, the MPU decided, based on the lack of agreement between the applicant and the students, the MPU, and even the Georgia State Police Department, that this was not an application that the parties were agreeing on. And so the LRB denied the application. That is quite a bit of evidence, Your Honor. That is quite a bit of testimony. That is quite a bit of inquiry on the part of the board. This is not a situation where the board arbitrarily decided, we're just not going to give you a liquor license. This was a very well thought out, lengthy and detailed inquiry into his operations, his security plan, his traffic plan, and how he anticipated or how the community would receive his business. And ultimately, the decision was a denial. Now, that was sent to the mayor's office, and due to no action on the part of the mayor's office by operation of the law after 60 days, that went into effect. But this was not a situation where the evidence was lacking. This was not a situation where the NPU made a decision without fully vetting out multiple issues. This was a well thought out and well-researched decision. And for those reasons, Your Honor, that's we believe that the court should uphold the decision of the LRB. I think it may be helpful if I could read one part of the transcript for the court, and this is in the record. This was...
Which date? Thank you, Mr. Prather.
Yes, Judge. It would be the final LRB hearing, which was November the 12th. And these are comments made by board member Carey. And so board member Carey raised the motion for the committee to go into voting. And he says, in my motion, I understand in this situation here, we're dealing with a conflict between business interests and the welfare of the community. I understand where the owner's coming from with regard to his investment and wanting to get returns on his investment and certain things he needs to have in place to make that happen. But at the same time, this board here is charged with weighing what's good for the health and welfare of the community, which include the community, the churches, schools, and everything surrounding that particular business. And also looking at the character of the person or the entity that's trying to move in here. In this situation here, we have heard endless testimony from students of a nearby university, Georgia State University, that has freshman dormitories within a few yards of this here facility. Mostly people, 90% of those in that dormitory are underage and cannot purchase some of the goods that we're sitting here talking about here today. We've heard from administrators from GSU. They've been here at endless meetings talking about the problem that this place has caused for their students and how it interferes with the welfare of their students' matriculation. We've heard from students who actually spoke about how it affected her welfare and her matriculation. I've attended several universities and I've never seen a dead body out my window. He goes on to say, we've heard from the campus police who have spoken about their objection to this here business being at this location. Very rarely do we get the campus police or any police officers to come in here and venture what their position is because they have a role to protect the entire community. And so typically they don't come in here. We heard from a police chief who also testified that since this location has been closed since February of this year, there's been no incidents at this location. He goes on and on and talks about other people they heard from, pastors, neighbors. It's a long list of people that spoke at that hearing, Judge, to express their concern about this particular license and specifically about the applicant's inability to meet some of the requests and the needs that the community demanded in order to feel safe. So I did hear Mr. Siegelman's previous argument that his client was being, I can't think of the word, but essentially he is being mistreated because of the sins or the crimes of the prior owner. But I want the court to focus on that there were specific opportunities for this owner, this new owner, this applicant to make changes to his security plan, to his parking plan, to his operation of business at the request of the community that he chose not to. And that was part of the reason why this application was denied. So for those reasons, Judge, I think that there's a wealth of information here that would allow the court to uphold the LRB's decision. In addition, Judge, there's one other code provision that I'd like to read to you, and then I'll wrap it up. It's Code Section 10-109G. And I'll have to find that one myself. So under City Code Section 10-109, there are several procedures listed that cover situations where a application can be denied for due cause. And in particular, I will point the court to subsection G, which reads as follows.
I'm going to object quickly. I certainly want to give opposing counsel as much opportunity to say what they want, but this was not a due cause hearing. This is not a due cause proceeding, and any due cause standard or elements are not relevant or pertinent to the matter before the court. So I just wanted to say that before Mr. Prothero continued. Thank you.
Understood. Thank you, Mr. Siegelman. Mr. Prothero, you can continue.
Thank you. Under subsection G, it says the mayor may, upon a finding of due cause, deny, revoke, suspend, or refuse to renew any license upon a determination that public convenience and advantage would not be promoted by the approval of an applicant's application. In making such a determination, the mayor may consider the general welfare and safety of the community, noise, parking, and traffic, with reasonable consideration being given to the character of the area and its peculiar suitability to the purposes used, to the proposed uses, and the stability of the neighborhood as they may be impacted by the proposed licensed premises. The decision of the mayor may be appealed via certiorari to the Superior Court of Fulton County. This is under the due cause section, Judge. However, subsection I states that the provisions of section 10-109 shall supersede any and all of the provisions of the city code of ordinances with which there exists a conflict. And it goes on in subsection J to say that the provisions of section 10-109 shall apply in all respects to anyone seeking to obtain a license or to the holder of a license to sell alcoholic beverages in a leased location within a leased premises. So I point that out, Your Honor, only to point out that the code does take into consideration that there may be situations where a license may be denied because of the character of the neighborhood and because of the community outcry. And so for those reasons, I asked the court to uphold the decision of the License Review Board.
Okay. Mr. Siegelman, your response?
Thank you, Your Honor. I'll start where we left off. So just because opposing counsel recited a code section that doesn't apply to this proceeding, I just want to point out how and why. Subsection C of 10-109 within the city code says, no application for a new license shall be denied or no license issued by the city shall be refused except upon a finding of due cause and after a hearing and upon a 5-day written notice to the licensee stating place, date, time, and purposes of such hearing and setting forth the charge upon which the hearing shall be held. So it is undisputed and I'm sure Mr. Prothero will concede because he would need to, it's not in the record, there was no due cause hearing. This is not a due cause matter. There was no such notice, and that provision, in fact, all the provisions that he just mentioned don't apply to this situation. So I'll start there. The one, and I intentionally did not chime in until that point with the city's council, because I think it's important for your honor to hear. Well, first off, at no point did Mr. Prothero discuss the objective standards. I think that's important. In fact, when he was summarizing the comments of the, I guess, the individual members of the public who expressed some concern, that it boiled down, they were concerned that there could be, and I'm quoting, a potential increase in crime. That is not an objective standard. That is a subjective concern that is not tied to any tangible evidence, no evidence whatsoever. I'll get to the any evidence standard that he began with, but that is what he's arguing, is that this application should be denied because of the subjective concerns expressed that there could be a potential increase in crime. That is not a justifiable basis to deny an alcohol license under Georgia law. Indeed, the comments when Mr. Prothero did, in fact, return to the transcript and recite directly to it, even the LRB member who moved for denial couched his terms of denial as a belief that the License Review Board should weigh the health of the community and the character of the person applying for the license. Weighing the health of the community and the character of the person applying for the license. Those are two highly subjective concerns that are not tied to any objective criteria. And those terms can mean different things to different people. And that is exactly why we have to return to the objective criteria and the code, which again, opposing counsel did not even mention or go through. Finally, just returning to the transcript, following the excerpt that opposing counsel read, later in that same recitation from the same board member who moved for denial, he also stated, now we know that this is some new owners and that they did not have anything to do with what happened there previously. And although that may not have changed the moving member of the License Review Board with regard to their motion to deny the license, that is a critical point. All of the so-called evidence, which again, we respectfully contend, while it's helpful to hear, does not actually have any impact on the issuance of this license, because the concerns raised were about those under prior ownership. The other reason why I was happy to hear some of the remarks by opposing counsel is because he talked about all of the efforts that my client made to try to meet the demands of the NPU. There is no requirement in the code for an applicant for an alcohol license to have a security plan, or that the applicant negotiate, much less negotiate a security plan with the applicant. Yet here, in good faith, that's exactly what my client did. And I don't expect opposing counsel to have a complete understanding. I know there was an issue with their counsel, and I know he's stepping in, but I certainly would object to some of the representations he made, because it was actually the NPU, our client, agreed to conditions set forth by the NPU, and then the NPU came back and said, no, we want to change those conditions, some of which my client was then not able to accommodate. But again, none of that is part of the objective criteria. All that it demonstrates is that in this case, the petitioner went indeed above and beyond trying to accommodate the concerns of those in the community, and apparently fell short enough where the LRB was moved to deny based on these, again, generalized concerns that should not have any bearing and do not legally have any bearing on the issue of this license. And finally, just returning to the standard that opposing counsel recited, we know very well the standard for a petition for review and are not at all disputing that standard. But Mr. Prothero seemed to hone in on the any evidence aspect of it, and that there was sufficient evidence to support this denial. But the problem with that is we are alleging a legal error. None of this evidence actually pertains to the objective standards. None of the evidence is actually to be taken into consideration when deciding whether to grant or deny an alcohol license. And therefore, there is no evidence at all that supports this finding or this denial, which we contend respectfully was clearly erroneous and is due to be reversed and this license issued to our client. If you don't mind, Your Honor, if you'll give me just one moment to confer with co-counsel and make sure there's not anything else that we feel we need to raise before you, if that's okay.
I'm happy to do that. Before you do, you don't have to answer my question right now. You can consult while you do, but I do want to ask a question, which is just to sort of follow up on the city, as you correctly pointed out, has said there's lots of evidence in this record, and there is sufficient evidence to support the decision that was made by the LRB. And you have said, well, that's not really the argument that we're making. The argument we're making is that they applied the wrong legal standard, or that they made a legal error. And I just would like for you to address that a little more in terms of the arbitrary and capricious nature that you've asserted of the decision, et cetera, and what legal error in as plain a terms as you can make. Was it that they applied the wrong legal standard? Was that they considered improper legal evidence? That's really what I'm not quite understanding in terms of the legal error. I understand you assert they made a legal error. What is the legal error you assert they made?
Sure, Your Honor. I'm going to answer that in two parts, and I still would like to confer with my co-counsel before I close. But I'm going to read from the city code and make sure that I read this correctly. I mentioned earlier the preamble to the city code concerning alcohol licenses, and I think it's worth at least referring back to that. So at section 10-2, called purposes of this chapter, it's the first substantive subsection essentially behind definitions. It states that this chapter has been enacted in accordance with a plan for the purpose, among others, of promoting the health and general welfare of the community, to establish reasonable and ascertainable standards for the regulation and control of licensing and the sales of alcoholic beverages, to protect and preserve schools and churches, among other purposes. But it states at the beginning that we have created, under law, reasonable and ascertainable standards for the purpose of protecting the health and general welfare and to protect and preserve schools and churches in the neighboring and nearby areas. So it's those objective standards that are in place specifically for the purpose of granting or denying an alcohol license. And again, there's been no dispute before Your Honor, and all the evidence in the record states that our client meets every last one of those standards and criteria. And so your question is, what is the legal error? Well, the legal error is denying an applicant for an alcohol license when they meet all of the criteria for the issuance of that license. And under Georgia law, and I'll refer back to that case, and in fact, I'll read directly from it because I think that may be most helpful to Your Honor. This is In Re Cherie Baps Corp., Georgia Court of Appeals 2018 case, citation 346, Georgia Appeals 434. And it talks about this. In this case, it was the Gordon County Code of Ordinances, and the court acknowledges standards for issuance of alcoholic beverages are set forth in the Code of Ordinances, and continues to say that although public comments were received opposing this application, that any absolute or uncontrolled discretion by governing authorities to issue licenses invites abuse, and the exercise of discretion, that exercise of discretion must be tempered with ascertainable standards by which an applicant can intelligently seek to qualify for a license. Thus, in Georgia, a liquor license ordinance must provide sufficient standards to control the discretion of the governing authority and adequate notice to applicants of the criteria for issuance of the license. And goes on to say here, just like in the city of Atlanta, but this was a different code of ordinances being addressed. There's an objective standard regarding the location. The location was at issue in that case, where the license is to be exercised. And finally, just before reversing the Superior Court, the Court of Appeals states this subjective concern by the testimony was not substantiated by any evidence. Again, there was, first off, any evidence, it's acknowledged in the record pertaining to the prior owner, which is entirely irrelevant here. But even if there was any evidence, there were no citations, no direct evidence of anything related to the prior owner, which again would not affect this application under different ownership. There's no evidence such as underage sales of tobacco or alcohol, not a case of criminal activity responsible by the anyway, I'm sorry. The ordinance requires more than a mere subjective concern and requires the evidence not merely be in regard to proximity, and talks about the different cases under Georgia law, because there are other cases talking about the subjective standard. This just the objective standard. This just happens to be the most recent one from the Court of Appeals. So I hope that answers your question regarding the legal standard. It is well settled under Georgia law that that any attempt to allow discretion, such as a subjective interpretation regarding the possible increase in crime, or subjective considerations of what might be in the best interest of the health of the community or the character of the person, those are subjective concerns not tied to any objective criteria in the code, and therefore any decision based upon that subjective criteria that cannot be considered is clear legal error, and therefore it was legal error to deny this license.
Understood.
My co-counsel may have a better answer.
Why don't you take a moment? You asked for a moment to consult with your co-counsel. I'm happy to let you do that. Just take a few minutes, and it's 11:52. Let's say 11:55, and we'll come back.
Well, you know what, Your Honor, my co-counsel wants to have the final word and is ready now, so we'll just let him answer your questions probably more articulately than I did. Thank you.
Okay. Mr. Berry?
Thank you again, Your Honor, for this hearing. And sorry about the technological snafu. We like to do things in person sometimes, and your jury room is nice this time of day. So thank you for accommodating us. I want to make 2 points, please, Your Honor. And the first, I think, reiterates your question to Mr. Siegelman. The court, the standard here is, as Mr. Siegelman was saying, that there was legal error made because the LRB considered subjective evidence. I don't even want to say it evidence, speculation, because as Mr. Siegelman said, there was absolutely no evidence at all about this owner, nothing. There was speculation that this might happen and this could happen. So it was legal error for the LRB to look beyond the objective criteria. Mr. Prothero confuses the issue, I think, respectfully, and points to the any evidence standard. But respectfully, Your Honor, all he is doing is pointing the court to a place it shouldn't go. The evidence that he points to is evidence that the LRB should have never even considered. There is no evidence, there's no dispute whatsoever about the objective criteria that were met. The second point, Your Honor, is more of a bigger picture issue. As Your Honor is well aware, the law likes certainty. The law likes a person to be able to look at a code and know what the outcome should be. The law likes certainty and likes black and white, and that's exactly what the city code establishes in granting an alcohol license. There are objective criteria that need to be met. Your Honor, respectfully, this is a classic example of Charlie Brown and Lucy and the football continuing to be moved. It's the exact opposite of certainty. I myself participated in many of those initial meetings where we sat around conference tables with representatives from Georgia State, with representatives from the NPU, with representatives from a nearby church, and in fact with a city council member, because our client was so committed to doing the right thing. Not that he needed to, but he was bending over backwards multiple times and coming up with security plans. And this is all in the transcript before the LRB, coming up with security plans that frankly he didn't have to do. But why did he do it? Because he was trying to be a good new neighbor. He met the conditions that the NPU was asking him in terms of security and hours and what they would sell and wouldn't sell. And I'll state my place because I was part of those conversations, but the criteria kept changing. All of that, frankly, is color more than anything else because it doesn't matter. The client met the application, met those standards, and it should have been issued. If the city is correct, it creates a frankly dangerous precedent because you know what? This court also needs to be worried about the next case. If the liquor store, if the convenience store 3 blocks up the road, are they going to be put through the exact same standards and exact same moving football of security guards and hours of operation and what products can or can't be sold? Or is the standard, the lowercase standard, if you will, from the city going to change every time and the football keep moving depending whether you're on Piedmont or Peachtree or Bolton Road? The standards need to be the exact same. It's not what the city's arguing that the standard gets to be different depending on the location and who shows up for meetings. There's absolutely no evidence here in the record, Your Honor, about this owner, about anything that this owner has done whereby he is not meeting the conditions. If the neighbors do not like the idea of a convenience store being able to sell alcohol, there's a solution for that, respectfully, Your Honor, and that is to go to the state legislature, and that is to go to the city council and build those criteria that they are trying to enforce here. Go put those in state law, go put those in city code, but they respectfully don't exist today, and it would be error, as we have said repeatedly, for this court to uphold the decision of the LRB because the football kept on moving, and respectfully, Your Honor, this court should not look at the football and should not look at those conditions that they kept trying to impose on our client. Our client met the standard, and this license should have been granted. We respectfully urge the court to reverse the decision of the LRB.
Okay. Thank you all very much. I have read the record that existed in the file that did not include the 2 September hearings. I'd like to revisit them. So I'm not going to rule today. I think what would be helpful, one, I have a request and a question. It doesn't control the answer to my question. It doesn't control the outcome. But my question really is to the city. I imagine and I'm assuming that if the court were to, Mr. Siegelman and Mr. Berry, if the court were to deny your petition and affirm the decision of the LRB, that you're going to take this up on appeal. Is that correct? And I'm only asking for procedural reasons, not because, again, it controls the outcome or is dispositive in any way. Mr. Berry?
We'd have to consult with our client, but I will
Mhm.
I will say that they've spent an inordinate amount of legal fees and time on this matter.
Okay.
And my understanding is if this is denied and we don't appeal it, then they sit out for a year before they can even refile another application. So that's a long way of saying we'd have to check with the client, but there's probably a reasonable chance that it would be further appealed.
Right. And then to the city, same question, right? If I reverse the LRB, procedurally, what happens next from the city's perspective? Mr. Perthor, you're muted. Wouldn't be a Zoom hearing if I didn't have to say that at least once, sometimes to myself. So
I'm usually good about not doing that, but today is that day. At this point, Your Honor, we would go back and review our options in our file as well. I do know that appealing this decision has been discussed and is on the table. I don't know if that would be the final decision, but I do know that that is a likely outcome.
okay. Again, I ask only for my process in terms of what I expect the parties to undertake next. That was my question. My request is, I don't need you to reinvent the wheel, but if each side could send me a proposed order in Word format so that I have those as something that helps me crystallize the parties' particular positions. I would very much appreciate it. Not in a super hurry, but want to be timely for you guys reasonably. How soon do you think you could get something like that to me, Mr. Siegelman?
I would,
Yeah.
Your Honor, I would like to say a week, and that's typically what I would suggest. I actually, my brother-in-law, my wife's brother, is getting married next week, and I'm going to be out of town for a chunk of next week, and I'm fearful that could present an issue. I mean, maybe 10 days. I mean, certainly no more than, yeah, I mean, by the 1st would probably be.
Yeah, like I said, I don't think it's necessary to be in a super rush. I just want to make sure that it's on the front burner in everybody's attention so it doesn't sort of get forgotten. Excuse me.
Judge,
So-
if I might throw Joe a bone, I would agree to the first 2 weeks if possible. One of my attorneys is going to trial next week.
Mhm.
And so I know that.
I think in front of me.
Yes, as a matter of fact. Yes, you're right.
Yeah,
Yes,
is it
you're
Miss
right.
Millord? I don't know, but I've got another City of Atlanta case that's supposed to go out on Tuesday.
Yes, that is correct, Judge. So
Okay.
I know that we'll be tied up next week. So if we could,
I mean, unless you can settle that case, but otherwise I look forward to seeing you on Tuesday. So yeah, Mr. Prothero, I think that makes sense. So what I was looking at, just to make it nice and even, is the 3rd of October is 2 weeks, exactly from today.
okay.
And so if that's not unreasonable and gives the parties an opportunity, and like I said, if you could just email them to Mr. Freehoff in Word format so that I can edit, cut and paste, do whatever I want to do with them, I would be very much appreciative in terms of aiding in my process so that I can give you guys an efficient response. Anything else that you guys need from me before we adjourn, Mr. Siegelman? You're
Joe,
muted.
you're muted.
Make sure that those, not that she needs to, but that those code sections are admitted into the record. I don't know if she.
My esteemed co-counsel reminded me that we would just ask that the code sections in particular, I think they were admitted, that Mr. Prothero didn't object. So although Your Honor has said you're not sure that it matters, we would just feel more comfortable if those code sections were formally admitted. And beyond that,
And that's fair. And I think what I said, Mr. Siegelman, was that to the extent that you believe that procedurally there's still a need for them to formally be admitted, Mr. Prothero didn't object, and I don't have any concern specifically stating that they are admitted. I was just pointing out that I think that might be an artifact of a time when it was much more difficult to access, locate, and reference the various city codes. But Atlanta's is much more accessible now. But to set your mind at ease, those code sections that were referenced were not objected to, and I consider them admitted to the record for purposes of this hearing and going forward.
all right, thanks so much. Nothing further from petitioner.
Anything else from the city, Mr. Prothero?
Nothing from the city, Judge.
Okay, excellent. Well, I guess I will see Ms. Millord and possibly some other people from the city of Atlanta on that matter starting actually I think on Monday, because we have our final pretrial on Monday. So I'll see you guys
that's
then.
correct. I think we have pretrial Monday and go out on Tuesday.
That's
Yep,
correct.
and actually, I have the final pretrial of the case that's ahead of y'all this afternoon, but
Okay.
they started with 12 defendants and they're down to 2. So we'll see if those 2 really feel like going to trial. Who knows?
Nice.